Sitaram, Kakarala. I work with the Center for Study of Culture and Society, and I also coordinate a small interdisciplinary program called Law Society of Culture. I had a background of teaching in the National Law School before joining CSCS. I have the honor of moderating this first session, which is Themes in Legal System Reform. And before I introduce the panelists, I want to just take my own sort of spin on the title of the conference. The subtitle is the Empirical Baselines and Normative Frameworks, and for my own convenience, I'm assuming empirical baselines is inclusive of institutional ethnographies as well. The themes in legal reform, in the context that we are starting about 15 minutes behind the schedule, let me quickly introduce the panelists. We have 4 panelists. 3 would make presentations and 1 response in general to the panel. 1 in absentia. The paper will be read by another presenter. The themes in legal system reform, as Sudhir said, is the overarching panel to a theme which I would guess is probably at an important juncture, because we in India have always spoken about legal reforms ever since we are independent. But there are some intermittent critical moments, and perhaps there were moments of certain kind, and if I can probably put Crisis of Indian Legal System of Upen Bakshi in late 70s, just before the real taking of the public interest litigation sort of a thing, if I personally speaking put as one critical turning point of sorts. The last few years seem to be critically indicating of one such turning point, and I think therefore a conversation on legal system reform, but not as very rightly cautioned by Sudhir, but not as direct programmatic blueprints of change, but rather a reflection on institutions, norms and practices. And I think that would obviously create an ambience of new dialogue, and I'm assuming this conversation, with all the modesty that Sudhir said, would begin a process of that kind, and I really congratulate the Azim Premji University for taking this initiative. The panelists for this particular overall thematic panel would be Sudhir Krishnaswamy, who is currently with the Azim Premji University, Professor Azim Premji University, and the one who coordinates the law governance and development program that he mentioned about. Sudhir did his doctoral work with Oxford University, subsequently worked in the National Law School of India, Bangalore, and subsequently West Bengal National University of Juridical Sciences. Sudhir's also worked in a number of expert panels, Prime Minister's Committee on Infrastructure and Kasturirangan Committee on Bangalore's governance. He published widely in various academic and periodical journals, and he published the book Democracy and Constitutionalism in India. I'm sure most of you are familiar with that. His interests include the constitutional law, administrative law, intellectual property law, and reform of the legal profession and systems, and legal education in India. He didn't mention jurisprudence, though he taught as my own acquaintance. The second presenter will be Dr. Wang. My Chinese pronunciation could be wrong, so please bear with me. Who is from University of Pennsylvania, and also he is with Associate Professor and Faculty Law of the National University of Singapore. And he did his studies at Oxford and Peking University, and also his teaching and research interests include international economic law, corporate law and securities law, and law development and Chinese legal system, and he published widely and so on. And his paper he is presenting in absentia would be presented by Madhav Khosla, who is currently pursuing his PhD in Harvard and formerly associated with Center for Policy Research and an alumnus of National Law School, Bangalore. The third presenter would be Dr. Simon Chapman. Dr. Simon Chapman is a senior associate with the international law firm Herbert Smith, and he has specialist expertise in international arbitration and advises clients across a number of different industries. He spent a number of years at Herbert Smith offices in London, Paris, and Hong Kong. And in addition to his expertise with Herbert Smith, Dr. Simon has spent 6 months on secondment to the international disputes team of a global energy company in London. He also widely published, and he has a law degree from Oxford University, and he speaks English and French. That's what I'm told. So I suppose he's acquainted with both the legal systems as well. So to these presentations, we would have a response of Dr. Pratap Mehta, who requires very little introduction to this audience, who is currently the president of the Center for Policy Research, and he was formerly working with Howard University and also with the Jawaharlal Nehru University. He was also a visiting professor at NYU Law School, and his areas of interest include political theory, constitutional law, society and politics in India, governance and political economy, and international affairs. Professor Mehta has his studies in philosophy, politics, and economics from Oxford University and PhD from Princeton University. So I broadly and briefly introduce the panel. So may I request the panelists to take, in the interest of time, take note of their clocks, and I request each presenter to be between 15 and 20 minutes, and then we'll be having the response, and then we'll open to the audience. Thank you. May I request it?
Podium very quickly, but it's the last time that I do this. So I'm going to take some time to try and outline what we are thinking behind the ideas behind this conference, and to try and outline what kinds of problems we think legal system reform needs to address in India. I'm going to start, though, in a very different place, away from the academic literature. I'm going to start with Vijay Tendulkar's celebrated Marathi play, Silence the Court is in Session. It's a rough translation, and since I don't know Marathi, I'll stick with that. Arguably the most insightful parody in Indian literature on court systems, and surprisingly not, given the current environment where everything gets censored, either by Parliament or the courts. It's quite surprising that this has not been censored at all. And like all successful parodies, it's deeply insightful because it hits upon some remarkable truths, and then builds on that to tell this remarkable little story about the way Indian law operates. For those of you who are not familiar, it's a play by an amateur, semi-rural or semi-urban troupe. They go off to a new venue, and they want to stage a trial of Lyndon B. Johnson for developing nuclear weapons. As they prepare for this trial, it's a staged play, they decide to practice, to do a sort of mock version of the trial in preparation for the real performance. And what it ends up being is a very incisive trial into the personal conduct of a 34-year-old single woman teacher who is part of the troupe, and her life story becomes the focus of the trial. And that's the sort of the treatment in the play, and it makes for great reading. Vijay Tendulkar's very perceptive. The play starts with one of the counsels pressing for a 15-second adjournment because everyone needs to use the spittoons to clear their pan. and so it continues with very tightly drafted pieces of putting this remarkable story of a court trial together. It's not a play that sticks to the script in that it's not terribly legal, in that it's more a human account of someone who has aborted a baby. And that's the focus of the play. What is striking in the play is that it does a few things that you'd never find in an Indian courtroom, which is that the entire evidence, the argument and verdict happens in a single day, in a single sitting. And this is what is called, in the literature on legal system reform, it's called outcome date certainty. That you know when the trial will finish. And it might be purely for dramatic effect that Vijay Tendulkar uses this form, but interestingly, it might be the most important thing in that play, which somehow the sort of the leading lights of legal reform in India have never got around, despite the extensive analytical and theoretical work that has gone behind legal system reform. No one has ever spoken about this as being a sort of a key to getting the Indian legal system to work. He also does something else. He shows us that there's very quick disposal. It's disposed. The person's found guilty, and in this case, it's a mock play, so it's not legal outcomes, but the outcomes of social censure are damning and very effective in this case. But what's striking is that what the play reinscribes in its outcome is so fundamentally socially conservative expectations of what single women should do in India. So the outcomes are brisk and delivered, but not outcomes that one might generally desire in any legal system. So what you get in Vijay Tendulkar's piece is quite a remarkable account of what is happening in Indian law. In two respects, that it's in the everydayness of Indian law, it's quite this sort of it's banal and never-ending. He brings it to brisk conclusions. At the end of it, we don't seem to do very well in outcomes. So even if we take a narrowly instrumental view, and some of the conference panel description and the background note might suggest that we might be guilty of doing that, of taking a narrowly instrumental view of institutional reform. Even if we get it right, that we get a brisk and efficient court system, if we have a court system that reinforces social hierarchy and this kind of outcome, then we won't get very far anyway. So Vijay Tendulkar, in that sense, is insightful on this respect as well, that we would do badly to just focus on a narrow institutional account of legal system reform. But strangely in India, the structure of academic literature has recognized this earlier, much earlier. And here I'll just use his two bookends, the two Bakshis. And Upendra Bakshi in his early work in the 1980s, Ram cited The Crisis of the Legal System, points out very strongly that we should not with legal system reform end up creating such a powerful court system that is deeply oppressive and regressive in an Indian social context. He even suggests that what passes for legal reform is merely an increase in state power through the expansion of the legal system. So he suggests that this is an oppressive agenda. He's very skeptical of the rule of law claim and the access to justice claim, and so on. Ironically, the bulk of the book, the remaining part of the book, details why the delays of the legal system have the most have perverse social outcomes. So, in a sense, the introduction and his theoretical work, to my mind, sits quite contrary to what the rest of the book so convincingly demonstrates. That if you have a legal system with which doesn't work. The people worst affected are the poor and the marginalized. I'll just cut across to my other bookend, which is Pratiksha Bakshi's work in 2007. I just use this as much for I'm not suggesting that this is the entire literature. I'm just using these as symptomatic of where the literature goes. And she rehearses that argument in a 2007 article where she suggests that the access to justice and rule of law type reform agendas, they're all narrowly instrumental. One focuses on access, which is, they focus on the access part of access to justice, and the rule of law part is just a narrow instrumental institutional improvement, institutional delivery kind of argument. And so what you get in the Indian literature, just this sample of the Indian literature, is a deep skepticism about the possibility of meaningful legal reform that enhances social welfare. It seems that a serious engagement with legal system reform, that is, if we improved our court system tremendously, we might end up with only enhancing the power of the state and might end up with a more oppressive political society. And so that is the point that I want to start this conversation with, which is that, is this necessarily the case? Can we provide or can we develop an account of legal system reform that doesn't suffer, at least with the extreme case that the two Bakshis suggest? Interestingly, I'll start with where Pratiksha concludes, and we were very keen to have Pratiksha here herself, but for various reasons she couldn't make it. Pratiksha concludes looking at Harsh Mandar's Nyayagra experiments in post-conflict Gujarat in 2003 onwards, and suggests that that kind of social dispute resolution, that is non-state communitarian dispute resolution, she doesn't, to be fair to the piece, it doesn't argue that that is the way we should go, but in the way the piece is structured, it suggests that that is the way we should think about the nature of dispute resolution, and that this might be, in some ways, a uniquely Indian or a developing country view of how legal system reform should proceed. So in the second part of my of this talk, I want to focus on this, on informalism and non-state dispute resolution as being a key vector in thinking about legal system reform. So the Nyayagra example in post-conflict Gujarat emerges from the recognition that even if you improved access to the state courts in Gujarat, justice outcomes were not delivered. And that is true. In that sense, to the extent that the data available on Gujarat in 2003 suggests that you had a problem of a wicked legal system, which is an exceptional problem. A legal system that itself seems to be oriented towards perverse aims. So it might be a fair characterization of what was happening in Gujarat at the time. But what she suggests is that social workers can bring about conciliatory settlements or solutions to disputes among various parties effectively. Now, I want to start my analysis of this prospect with Gallanter and Krishna's work on the Lok Adalats. For those of you familiar with this literature, it shows that Lok Adalat type proceedings, which are not fully, they're not non-state and they're not communitarian, they're communitarian in a sense, tend to have evolved into exercises of charismatic or patriarchal and very occasionally matriarchal authority, where judges are able to wield, or retired judges are able to wield forms of social power unregulated by the requirements of due process to certainly resolve disputes. They do a very good job of resolving disputes if numbers are the basis of evaluation. But the outcomes of those disputes leave much to be desired, and the process of resolving disputes leave much to be, are certainly subpar. mediation in India has tended to move from a consensus-based authority, which is the legal foundation of mediation, to a similar sort of charismatic or patriarchal authority format in the way mediation is practiced, even in the boundaries of the Indian court system. The court process, and I'll just, because Pratap said, I'll just use his work as an example. The formal court process, which is supposed to be bound by all the norms of process, legal process, has also started in India to resemble, to emphasize the values of compromise and settlement. Adjudication almost looks as like the judges are trying to find some reasonable settlements that parties can agree to and live with. And that sense of informalism has crept into the formal courts, where adjudication is seen as this master exercise in social conciliation, practiced by judges, unaided by law often. So you have along the spectrum of informalism the truly non-state adjudication as well. You have people's courts of the two varieties. The people's court of the Maoist movement, which are not strict adherents, let us say, to due process, but you also have the people's tribunals of civil society movements, which follow due process in form more often than not, but do so in an almost caricatured format of what a court must be. So you have in India, I suggest, a range of informal methods of dispute resolution that in various ways some may rely on the court system and some may not, but seem to be, for some participants in this debate, the more successful way of resolving the problems of the Indian legal system. So I started with an account of legal system reform that one might find from people who would identify themselves as on the left of the political spectrum. What is interesting is that this informality finds acceptance across the political spectrum. So the World Bank's Justice for the Poor program is called the J4P program. A major prescription is the avoidance of the court system. Its major prescription is that to address issues of poverty and exclusion, the best way to go is to use paralegals and non-court based resolution. The latest work in this area is by, it's called the Strategies Towards Basic Justice Care for Everyone report, which is, I think, 4 days old. And its major prescription is this: the role of facilitators and paralegals working towards settlement as one of the best strategies to promote access to justice. So you find a curious coming together of very diverse political agents. I mean, people who identify themselves as being on two different sides, seemingly come together with the prescription that an informal approach to dispute settlement, a community-focused approach, is where the solutions to legal system reform are. So while we need not assume as we start this discussion that a state-based dispute resolution system must be the centrally located as the main pillar of dispute processing in any society, we must seriously ask whether, and study in an empirical sense, whether these other forms of informal dispute resolution truly bear out on this promise. That is, that they do not have the hazards of process, but they provide justice-enhancing outcomes. Now, you might find that I've started, for those of you who paid attention to the schedule, I've started this conversation with a theme that is barely addressed in the rest of the conference. And there is a reason for that, to my mind, which is that we have not done any work on this aspect of the court system. We have looked at mediation outcomes, and we are very skeptical of the broad brush claim that mediation disposal, that is a disposal rate analysis of mediation, it somehow maps on nicely to this justice enhancing type outcomes that people make it out to be. So I sense that this is a central question in legal system reform, the state versus the non-state forums for dispute resolution. It is not a question, there are others we have a panel on alternative dispute resolution that skirts around this issue. We don't have anything on the Maoist courts and we don't have anything on the people's tribunals. But I don't think that literature is readily available, it hasn't been done, and it needs to be done. And that is one central question that legal system reform in India will have to address. What is the extent to which non-state dispute resolution will come to dominate legal system reform? So that's issue one. So the second thing that I will turn to is the formal legal system. And here I want to organize the theme. Yeah, are you thinking my turn? Okay. I want to organize the discussion as one about bridging academic and policy debates. And I'll try and suggest reasons for doing that. The central concern in policy debate in India has been court congestion and backlog. Now, this has become almost the singular problem that legal system reform advocates in government and on the boundaries of government, that is the institutions around government, have come to stress. Elizabeth Kolsky, in her history of early colonial government in India, suggests that the colonial government was never interested in building vibrant criminal law institutions, because if they did that, if they spent a lot of money on that, it would hurt very much the planter economies that were trying to be developed at the time, and that it would not only stall the project of the plantation economy, but also potentially stall the projects of racial superiority that were integral to that part of colonial history in India. What's interesting in Kolsky's work is that she sees that underinvestment in a legal system, it damages the interests of the most marginalized. And that comes out very clearly in her work in a way that in subsequent literature on this topic is completely lost as to who does a fully functional legal system serve. So while Kolsky focuses on the criminal law, Mendelssohn and Portage focus on different aspects of the civil law, on the land revenue system, and in Bengal and then in Punjab. And what you see in this literature is the emphasis on a peculiar cultural problem in India, which is the frivolous and vexatious litigant, as being a central figure and a problem in Indian law. And this, incidentally, has remained. Today, the frivolous and vexatious litigant most often referred to is not the land revenue, not the patadar of the time, but the woman who is harassing men using the Domestic Violence Act. So the narrative has remained about frivolous and vexatious litigation, but very little analysis of what that really means. What kinds of interests motivate people to be in the courtroom. And we have a very interesting presentation later on Pakistan on the interests that motivate parties to come to court. But these two issues, court congestion and frivolous vexatious litigation, were picked up by the Rankin Committee in 1924, which studied civil justice pre-independence and said that these are the two really serious problems that we should contend with, and somehow this has become the template for policy discourse in India ever since. Every subsequent law commission report and government body seems to repeat these two elements as being somehow the best explanatory indicators. This is what we must study. If we can get rid of court congestion, and if we can get rid of the frivolous and vexatious litigant, then Indian legal system reform will get home. So you find that the policy prescription then is simple. We must dissuade the frivolous litigant, and we must enhance the capacity of the courts. And these two dominant ideas have captured legal system reform in India. Having said that, I would identify 2 or 3 other trends, and I'll do it just telegraphically for now. The use of special courts. So wherever we found that the courts were getting congested, we just create new courts. We create debt recovery courts, we create tribunals of various sorts, family courts, consumer courts, and so on, and then find usually a decade later that those courts are in no better shape than the regular court system. The procedural reform, that's adjournments and bail plea bargains. I'll just give you one example here and I'll quickly move on. A curious thing is plea bargains were put out as being one of the most important ways and pushed by multilateral institutions as being one of the significant ways of reducing congestion in the criminal court system. And I would ask you to guess how many plea bargains have been recorded in India in the last few years. And I can tell you anecdotally, though we're struggling to get data on this, that the answer is 0. And that there's been no plea bargains recorded. And the approach to legal system reform, this is legislative reform, has been simply to bring piecemeal reform either on adjournments or on plea bargains, as if these would sort out the problems of congestion and the frivolous litigant. We also have seen diversion as a major strategy, arbitration, mediation, and other forms of non-court dispute settlement, of which we find in a brief summary that mediation is the only format that seems to at least deliver disposal rates. The other forms have not even delivered on disposal in our diversion strategies. So I think I have 1 minute left. So let me try and pull this together in a new way. So the empirical, the policy debates in India are quite stagnant as to what is needed to be done. I don't know what the problems are, but the solutions are the same. The solutions are you tackle court congestion and you deal with the frivolous litigant. You tackle court congestion by enhancing number of judges and number of courts, and you tackle the frivolous litigant by changing legal rules. And if you do these two things, the legal system will somehow become a well-oiled machine. There is no clear direction that one can decipher on the way this is going. The recent talk about court management and so on has hardly been implemented, so we don't know where court management is going to go. But I'm going to suggest to you, and I'll close here, that this is unlikely to even get off the ground because the approach to legal system reform is fundamentally uninformed by the kind and quality of empirical data that is necessary for this project to get underway. If we take easy resort to strategies that have been developed and worked in other jurisdictions, and here I just hold an exhibit in the plea bargain, it is very unlikely that unless we are given another institutional environment for the legal system, that any of these will work. And case management, insofar as information is publicly available, seems to belong to the same class of reforms. It has been used in other jurisdictions relatively successfully. Is it going to work in India? There doesn't seem to be a reasonable basis to believe that that will happen. And I say two things here. Then what kind of empirical data? Clearly, quantitative data in India is very poor, and we don't need quantitative data at aggregate levels, which is what is available today. The interesting work of Arnab Hazra and others, and some of our own work, suggests that what's important is local and disaggregated data. Disaggregated by case, by court, and by type of process, and you can't have these national prescriptive forms that will somehow do magic in India. That's the first thing that we pick up. Second, that you cannot do this work without qualitative empirical data. And here I'll just use one work that I think is just about the only work that I can cite that gets here, which is Barry Walsh's work using the ADB studies on empirical studies on the courtroom in New Delhi. And you see that Barry Walsh's work comes up with very different conclusions to what the rest of the the legal fraternity, that's the political and legal fraternity, seem to think are the solutions for legal system reform. And I'll just conclude with Barry Walsh's work as an example of how this might change. He suggests that the most important thing is not precisely what process you follow, how many adjournments you allow, whether it is 3 or 5 or 15. What he suggests is most important is outcome date certainty. And the reason that outcome date certainty changes it seems to be this factor that, and he has a sort of a game theoretic explanation of why it works, is that it changes litigation expectations. The moment parties know that this is the end date of a dispute, it completely changes how parties relate to a dispute. It changes motivations for settlement. And there is no legal system in the world that processes through formal dispute resolution more than 25 to 30% of the disputes that enter the system. There's no other example of any legal system. So what has happened in India is that if we continue with a sort of narrow institutional account, as rigorous as our econometrics might be, of how institutional reform must proceed in the formal legal system, we are very unlikely that we will get anywhere with this phase of reform. And it's in that sense that our work at the Law Governance Development Initiative, we're trying to address that very problem. What is worrisome for us is that most of the policy participants in the debate and key actors seem to think that the academic work has already been done. And they seem to think, and you will hear some of them present later in this conference, they seem to think that the thinking work is over. All that needs to be done is execution. The templates are ready, and none of these, ironically, none of these templates or data sets are available in public, so we don't have a traction on what they are thinking or what they propose to be the next magic bullet. But the worrisome part of this conversation is that the policy space today is almost completely severed from the academic conversations that need to happen around these important issues. And so let me just conclude by saying that we don't think that legal system reform has any meaningful prospect of success unless it is backed with very serious work on a normative understanding of what forms of dispute resolution are justice enhancing and promote an equitable society. And that normative understanding cannot proceed without a deep empirical engagement with the functioning of the formal legal system as well as the informal legal system. But unless we do this in a quantitative and qualitative way, that this project of legal system reform is likely to remain in kind of the situation that we are in for the last 100 years. Thank you.
Thank you, Sudhir, for that wonderful, broad, thematic overview of the issues on the contours of legal reform. I'm sure there are many provocative responses that you will await in the question-answer session. I'm quite just tempted to take 1 minute and add another point to what Sudhir framed as a formal-informal space. And I think if one were to go by whatever emerges from the work of the Comoros in the recent past, the law and disorder in the post-colony, especially the work on Africa, but I would guess the Indian context would not be too far away from it. The problem, the informal being viewed as part of the legal pluralism debates, or with the other modernist ambition of formalizing the informal, which is actually a part, the Gram Nyalays, the Lok Adalats, and so on and so forth. I suppose the limits of those paradigms are very clear. So therefore you need a rethinking on this whole question of the formal-informal tension, and I'm glad that he presented at least some take on that. So may I, now without losing time, we are a little behind, but thank you, Sudhir, for keeping tabs on time. We just overshot a few minutes. May I invite Madhav Khosla to come and read Dr. Wang's paper. I understand, I don't know how long the paper is, I understand the difficulties of reading someone's text, but I would hope that you would be able to manage that. Madhav.
I actually thought instead of reading it, if it's fine, if I just sort of flag the main themes in the paper, because I haven't had the chance to give it the time it deserves. But the 2 or 3 sort of interesting things about the paper is, the first is that the evolution of Chinese legal reform has been somewhat ad hoc, and it's been ad hoc in the sense that there are 3 influences on the reform culture which don't always go here. So the first is traditional Chinese legal thought. The second is socialist ideology, and the third is the westernization of Chinese law, and the third is obviously of greater moment as the Chinese economy integrates. The other really sort of big theme that the author tries to drive for is the fact that the law in China is viewed in extremely instrumental terms, and so the entire sentiment behind legal reform is that the law must be used as a political and administrative tool, and also it must be used as a tool for social action. And so the character of the reform takes that shape. The third interesting thing about it is that although there's a lot of borrowing from the Anglo-American world, particularly the US, the Chinese legal system and legal reform remains civil in one very important respect, and that's that the primary source of law is enacted legislation. And so case law has never gained legitimacy within Chinese legal structures. Now, the reform agenda in China seems to have been limited by, and also sort of, so it's taken a particular shape because of 5 or 6 reasons that the author mentions, and I think all of those are actually quite interesting. So one of them is that the judicial reform must adhere to the leadership of the CPC. The second is that the reform must be conducted within the boundaries of socialism with Chinese characteristics, and what Chinese characteristics are hasn't always been easy to discover, but it's clear that that it has to at least be articulated through that lens. The third is that there's been a certain degree of, despite the fact that the legal system is moving in Anglo-American ways, there's been a lot of suspicion of foreign law and of foreign legal regimes, and so the idea is that foreign elements should be borrowed extremely cautiously, and one must make sure that they fit in with Chinese indigenous conditions and with custom and those sorts of traditional aspects. The fourth interesting thing is also this, and this links up to the instrumental point I mentioned earlier, that the purpose of judicial reform is to promote social stability and harmonization. And one of the consequences of that is that that Chinese legal reform doesn't simply focus on a judicial solution. So we know that at least in a lot of other countries, one of the big sort of questions is what kinds of changes cases lead to, and whether cases can lead to social outcomes and so on. And it's a funny question in some ways, right? Because the purpose of the case is to lead to a legal outcome. But the interesting thing is that in the Chinese sentiment has been that you're not simply looking for a judicial solution, and it must lead to genuine social change, a resolution within parties, all of that. And the on-the-ground consequence of that has been that there's a move towards mediation. And so that's something that's encouraged, it's something that's gone up, because it seems to be that it seems to add a particular kind of, you'll get finality in the outcome either way, but this actually gets you a result of some sort. The other important characteristic of Chinese judicial reform that the author mentions now and again is the fact that it's driven by a desire to create effective coordination between different levels of government and different levels of the bureaucracy. So it's interesting that it's not so much dispute resolution then, but some it's like planning in some ways. And so the law is kind of viewed as something that can just sort of make the machine function better. And I mean, it goes without saying that obviously the one thing lurking behind all of this is the fact that the judiciary isn't independent of the ruling party, and that impacts the character of the reform that will be undertaken. Despite this, despite some of these sort of, which one may call sort of hindrances, there's been a lot of positives in the last 2 or 3 decades. So the first has been that there's, one or two relate to the changing character of the legal profession itself. So practicing lawyers have been given far more rights. They're playing a far more significant role than they ever played before. This is coupled with the fact that there's accelerated privatization of the legal profession. The third is that there's a move to create centralized funding for the courts so that they are insulated, and also their sort of financial models aren't sort of nebulously structured and not linked to local bodies and all of that. They've been legalizing trial procedures, and the final sort of really, what I found was actually quite interesting is the fact that more and more people are filing cases, and for the author, this suggests that the belief in the rule of law is taking hold in China. And one may agree or disagree with whether that's true, with whether if more and more people are filing cases, the belief in the rule of law is taking hold. I mean, one can sort of love the law but not be an enthusiast for it, right? But the interesting thing is that the author certainly believes that that's very, very important. And so the big change is that a lot more attention is shifting towards courts. People are filing cases, and it will be interesting to see as to whether the suspicion of case law and the general limits on it will change given that characteristic. So those are the sort of the main themes. I thought that it would be sort of more interesting to talk in those terms rather than to just read it out, because I mean, we'll all have the papers circulated. The author sort of he was very apologetic that we couldn't sort of coordinate with him, but he did say that if anybody has further questions, he'll be only too happy to answer them via email and so forth. So he will organize that.
Thank you. May I now invite Dr. Simon for his presentation. Thank you.
And have spent the morning battling the traffic in Bangalore, which I can say is probably slightly worse than the traffic is in Hong Kong. But I'm really delighted to be here, and I've been asked to talk a little bit about arbitration in India, and specifically the common perceptions that foreign investors have with regard to the effectiveness, if you like, of arbitration in India. This is a really hot topic at the moment in arbitration generally. I was speaking at a conference in Seoul a couple of weeks ago to a large group of in-house counsel, and the only two things that anybody wanted to know about were arbitration in China and arbitration in India. Arbitration in India is perhaps slightly more interesting of the two, and this ties in quite neatly with the overall theme of this seminar, because arbitration in India at the moment is undergoing a process of reform. There are lots of cases, one particular case which is pending before the Supreme Court, and judgment is eagerly awaited, I think, after the summer recess. But there are also some significant reforms which have been proposed to the domestic arbitration legislation, the Indian Arbitration Act, Arbitration Conciliation Act rather, of 1996. There are lots of things that you can say about arbitration in India at the moment, and I could stand here and talk all day about them, but you'll be to talk about problems with regard to enforcement of arbitration awards in India, and also problems with regard to the extent of court intervention in the arbitration process. International arbitration is obviously a very important form of ADR in the broadest sense, and that it is intended to be a complete alternative to the domestic court system in any particular jurisdiction. Arbitral awards are intended to be final and binding and subject to any minimal review by the courts. It's the most popular and perhaps most effective means of resolving international disputes, by which I mean disputes where you have two parties from different countries. So in the Indian context, that would mean that at least one of the parties to the dispute is not an Indian company. And obviously, as the Indian economy continues to grow and foreign investment in India continues to increase, arbitration and international arbitration specifically will become even more important. In order for arbitration to work effectively, however, it must be an efficient way of resolving disputes outside of the domestic court system. And there are really two things that are really fundamental to that. The first is that there should be minimal court intervention in the process. And the second is that awards should be easy or relatively easy to enforce, because your arbitral award is only worth anything if you can enforce it effectively against the assets of your counterparty. Now, the major international arbitration centres in the world, so the likes of Paris and Geneva and Singapore and Hong Kong, all pride themselves on these two hallmarks of having an effective international arbitration hub, which is minimal court intervention and the effectiveness of enforcement. And I think, unfortunately, it's in those two areas in particular that India, at the moment, is perhaps lagging slightly behind, and that's certainly the perception of foreign investors looking to arbitrate against Indian parties. There is a perception, I think, that the courts in India are perhaps too ready to intervene in the arbitration process at all of the different stages of a dispute. And there is also a perception that arbitral awards, international arbitral awards, are too difficult to enforce in India. And there are two limbs to that, really. The first is that because, and this is tied to the issue of court intervention, the Indian courts are perhaps too ready to set aside arbitral awards for things like breach of public policy in India, and that's something that I'll come on to talk about a little bit later. And the second issue, and this really touches upon what we've already discussed this morning, is the issue of delay and the backlog in the Indian courts, meaning that it can take you years and years before you are able to enforce your arbitral award effectively against the assets of an Indian counterparty. And there's been a recent case, White Industries, involving an Australian mining company that I'll talk about a little bit later, where it took 10 years for the party to try and enforce the award. Eventually they just gave up and sued the Indian government for breach of its international law obligations. I think the reasons why the perception is that India is lagging slightly behind other jurisdictions in terms of its domestic arbitration law is complex, and it's due to a variety of different things. The 1996 Act, which I mentioned earlier, which is the key domestic legislation in India, was intended to make arbitration more efficient, and it was intended to reduce court intervention in the process. The 1996 Act is based on the Untittled Model Law, which is really the internationally accepted standard of a domestic arbitration law. The Hong Kong Arbitration Act is based also on the Untittled Model Law, as is Singapore and most other jurisdictions, in fact, throughout the world. And the Untittled Model Law really provides a clear framework for the recognition and enforcement of arbitral awards, and also provides that the courts are only entitled to intervene in the arbitral process in particular circumstances and very restricted circumstances. Unfortunately, however, I think that the way in which the Indian Act has been drafted and the way in which provisions of the Untitled Model Law have been transposed mean that there are certain ambiguities in the Indian legislation, and that's given rise to a series of disputes since the Act came into force. And that has really served to broaden the scope of the court's powers to intervene in the arbitral process. The key case really that I wanted to talk about today in terms of court intervention is a decision of the Indian Supreme Court from, I think, 2002, Bhatia International and Bulk Trading, which is currently subject to a very high-profile review by the Supreme Court in the Barrett aluminium case at the moment. The Bhatia case concerns the scope of the 1996 Act and the extent to which the Indian courts can intervene in arbitrations which are seated in other jurisdictions. So most countries around the world have domestic arbitration laws which distinguish very clearly between arbitrations which are seated within that jurisdiction, we call those onshore arbitrations, and then arbitrations which have a seat elsewhere in the world, and those are called offshore arbitrations. And typically, the arbitration law, and this is reflected in the Untitled Model Law, will provide that the domestic courts have quite extensive and quite broad supervisory jurisdiction with regard to arbitrations seated in that particular country, but they have only very limited powers in relation to offshore arbitration. It's a fundamental principle of international arbitration, for example, that only the courts at the seat of the arbitration have the power to exercise certain functions in relation to that particular arbitration. So, for example, if the parties fail to appoint an arbitrator, you will go to the courts at the seat of the arbitration and have them help you with that process. And in some jurisdictions like Hong Kong, that function is entirely delegated to a particular arbitral institution. So in Hong Kong, it's the HKAIC, the Hong Kong International Arbitration Centre. If you want to contest the International Arbitration Award, you go to the courts at the seat of the arbitration. You can't have the award set aside anywhere else in the world. You must go to the courts at the seat. You will only need to go to the courts of another jurisdiction if, for example, you want some form of interim relief, so you want a freezing injunction against the other party's assets. But that, you have an arbitration that's seated in Paris, but the assets are all seated in India, then you would go to the Indian courts for their assistance in obtaining that injunction. You will also go to the courts of another jurisdiction when you want to enforce your award. So again, if you have an arbitral award that was rendered in Paris, but the counterparty's assets are all here, then obviously you will have to come to the courts of India, and if the other party doesn't comply with the award voluntarily, to enforce the award against that party's assets. And the Untitled Model Law achieves this distinction between the powers of the courts to be exercised at the seat of the arbitration, powers of the courts for offshore disputes, by saying that the entirety of the legislation only applies to cases where the seat of the arbitration is located within that jurisdiction, save for provisions X, Y, and Z in relation to, for example, interim measures or in relation to enforcement. And it's the reference to the word only which is key. Because unfortunately in the Indian legislation, the powers of the courts in Part 1 of the Indian Act, which are really intended to be the powers that are exercised by the courts for onshore arbitrations. Part 1 just says that this part of the Act applies to arbitration in India, but it doesn't say it only applies to arbitration in India. And so when this was put before the Supreme Court, the Supreme Court said, well, there must have been some reason why the Indian Parliament decided to depart from that specific language that was used in the Untitled Model Law. And that reason must be that Part 1 applies to all arbitrations, wherever they are, unless Part 1 is expressly excluded in the parties' arbitration agreement. Expressly or impliedly excluded, not in the parties' arbitration agreement. So what this means is that you can have an arbitration in Paris or in London or in Hong Kong, but the Indian courts can claim jurisdiction to appoint arbitrators or to set aside the award, and this has caused all sorts of problems, particularly for foreign investors, where they're successful in entailing an arbitral award in a particular jurisdiction, and the award is then set aside in India. The courts are, I think, aware of the criticism that's been directed at Bhatia over the last few years, and more recent decisions of the courts have tended to find more readily that there's an implied exclusion of Part 1 in the arbitration agreement. Usually by finding that if you specify a seat of arbitration that's in Paris and you have a governing law that's French law, then there's an implied exclusion of Part 1 of the Indian Act. But that is not always the case, and the fact that your seat is in Paris will not necessarily amount to an implied exclusion of Part 1. So we've been advising clients for some time that whenever you're drafting an arbitration clause in an India-related contract, you must expressly exclude Part 1 of the Indian Act in your clause. This has now come before the Supreme Court again, as I mentioned earlier, in the Bharat aluminium case. And because of the uncertainty that's been generated by the Bhatia decision, I think everybody is very optimistic that that line of authority will be overturned. The judgment in Bharat aluminium is expected, I think, imminently, and certainly after the summer recess at the latest. There is also a draft consultation paper that was circulated, I think, a couple of years ago in relation to a potential reform of the 1996 Act, and it was suggested that in order to avoid all of these difficulties, that word only, which features in the Untitled Model Law, should be incorporated into the domestic legislation to make it very clear that the Indian courts do not have the power to intervene in offshore arbitrations. A quick word then about enforcement, which is a critical concern for any foreign party with an arbitral award. How can you enforce that award effectively? Two concerns really with regard to India. One is the scope of the court's powers to set aside foreign arbitral awards, and the second relates to the delays in the process and the backlog in the Indian courts. The first problem about the scope of the Indian court's powers to set aside foreign awards relates to a decision from the Supreme Court, again from a number of years ago, ONGC saw pipes, in which the court expanded the definition of public policy. Now, the courts in all jurisdictions all over the world have the power to set aside arbitral awards on very limited grounds. If there has been, for example, a fundamental breach of due process in the arbitration, something went fundamentally wrong so that one party was deprived of the opportunity to present its case properly. And then a more controversial limb is if the award is contrary to the public policy of the jurisdiction where enforcement is sought. And it's this concept of public policy that the Supreme Court in saw pipes really latched onto and said that can be, that's very broad concept and can apply, for example, if the arbitral tribunal made an error of law in its reasoning. So if the tribunal was applying a particular point of Indian contract law, and it's a complex issue and there's reason to suspect that the tribunal may have got it slightly wrong, then the Indian courts can delve into the merits of the case again and decide to overturn the award if they think that the tribunal has made a mistake. Now that's controversial because it's, again, a fundamental principle of international arbitration law that courts are supposed to be courts of review, they're not supposed to be courts of appeal. So when you have a court which is delving into the merits of dispute and reassessing or second-guessing the tribunal's evaluation of issues of law, that can cause incredible difficulties, and it's not really in line with best practice internationally. Again, I think that the consultation paper on the Act, which was circulated a couple of years ago, suggests that the limb of public policy and patent legality, it was called in saw pipes, should be removed to restrict the ability of the courts to interfere. The last point I wanted to mention just briefly is in relation to delay, and this is the White Industries case that I mentioned at the outset. This created a lot of publicity at the time. The dispute related to a contract between White Industries, an Australian mining company, to supply mining equipment and materials to an Indian company. The dispute between the parties was submitted to ICC arbitration in Paris, and White Industries obtained an award in its favour, which it then sought to enforce against the assets of the Indian company in India. To cut a long story short, White Industries tried for about 3 years, I think, in the lower courts of India. Various different high courts were involved. There were challenges and then cross-claims and counter-claims as to whether the award was valid or not. Eventually the matter was referred to the Supreme Court, partly because of the uncertainties in the relevant legislation that I mentioned at the outset. So the uncertainties that have been created by Bharti and by saw pipes meant that the High Court decided this was of sufficient importance that it should go to the Supreme Court. And the matter was put on the Supreme Court's urgent list and stayed there for about 6 years until eventually White Industries gave up and decided to sue the Indian government under a bilateral investment treaty between India and Australia on the basis that the Indian government, by its failure to push the case through the courts sufficiently promptly, had breached its international law obligations and the investment protections that it had extended to White Industries, because it didn't have an effective means of prosecuting the award within India. Now, lots of people have said that this might spark a trend amongst investors in various jurisdictions around the world, not just in India. I'm not sure that that's necessarily true. I'm not sure that people would necessarily have the patience and the resources of White Industries to try for 10 years to enforce an award in a jurisdiction and then to bring completely new proceedings against the government for breach of a bilateral investment treaty. It does underscore, however, some of the real problems and the perceived problems of arbitrating in India and the delays which are endemic in the Indian courts, and the fact that this really puts people off coming here to enforce their contractual rights. So just to sum up very briefly, I think there is a current perception that arbitration in India is problematic, that the courts are too interventionist, and that awards are possibly too difficult to enforce. But there is lots of hope, I think, amongst the international community for positive reform in India. The consultation paper that was issued is a very good sign of that. It looks like things are moving in the right direction. The Bharat aluminium case, the judgment is very eagerly awaited, and it's expected that it will overturn the long line of authorities stemming from the Bhartiya case. And I think that India has very significant potential in the future to become an international hub for international arbitration. As I mentioned at the outset, it's the one thing that everybody wants to talk about when you go to see them, because of the level of investment that there is in India. So the outlook is, I think, positive, but I don't think that change will happen overnight, and that there is still some way to go. Thank you very much.
Dr. Simon, for very useful insights into the critical side of practice and what it implies for the larger theme of legal systems right now. We had 3 papers, 2 broad systems papers, and 1 very specific side of practice and implications for the system. I know it is very difficult to pull them together. There are a number of issues that have come, and one interesting theme from my own vantage point is the problem of the strength of law, which is, as using Scott Lash's frame, is the norm. judging or arriving at resolutions from the standard. Right? That's what law is all about in terms of 19th and 20th century practices. What seemed to be emerging from these presentations is the temptation to really work on the mediations or resolving little beyond the norm problematic, which is an interesting one. I don't flag further, but there is an interesting theme, the Chinese systems paper as well as Sudhir's presentation in the beginning, and then in the arbitration, of course. It's very interesting areas from my vantage point, but the responsibility of bringing this together and give an overarching response to the session lies with Dr. Pratap Bhanu Mehta. May I invite you to task.
These are three very interesting papers, and it's trying to think of what's common to all three of them, particularly the first and the last paper. And I think the way I describe what's common to them will not be very polite. I mean, it says it will not be polite to the Indian legal systems. You know, I think the papers are terrific. So if we step back from these three papers and say, okay, what's one common story all of them are telling, particularly the two Indian papers? I think one common story that comes out very clearly is what is the Indian judiciary all about? The Indian judiciary is a bunch of judges and a bunch of lawyers who have been authorized by various forms of state legislation and kind of the connections with the state. They extract rents by virtue of that authorization. And by rents, I don't necessarily mean monetary rents. I don't mean sort of corruption in the kind of conventional sense. But rents, as it were, of privilege, rents, as it were, of exclusivity in being able to judge disputes. So there's a reason why, you know, you go to a judge of the Indian High Court, but if Sudhir wants to set up shop outside and say, look, I'm a judge, please come to me, you're not allowed to do that. And we need to go into reasons why you aren't allowed to do that. They extract those rents. And essentially, they are going to, as it were, militate against any reforms that diminishes that extraction of rents. So what's happening in arbitration, essentially simple story, how dare anybody else set up shop here? What happens in informality, how dare anybody else set up shop here, right? What happens when you set up, you know, other specialized courts? You know, the first thing the Supreme Court says, well, hang on, you have to have judges on it, right? Okay. So at one level, right, the fundamental problem of reform is that you have a tightly knit institutional system that is essentially going to use its power to make sure that it collects, as it were, maximum rents and preserves its exclusive privileges in the system, right? And if you look at the history of resistance to reform, it's largely that, right? So when you set up specialized tribunals or specialized courts, judges say, no, you have to have judges on that, right? Where the rationale was precisely the opposite, to actually have specialized, in a sense, expertise. When you do arbitration, judges say, no, hang on, you have to have supervision of that, right? So I think one way of, in a sense, asking the question, but and I think it does point to something, which is nobody inside the system will want reform. Or rather they will want reform only when there are other very, very powerful groups whose rents in a different way are being affected by the exclusivity of this. So international investors might actually get their way, right? Because in a sense the stakes of big business in India are slightly different. And you might be able to actually get enough of constituencies to say, look, coming down from 8% to 7% growth rate will actually hurt you big time. It affects the rents of a lot of other people. The judiciary might actually move. Right? Will it move in other areas? Very, very actually doubtful. Right? So I think the first point is, in a sense, I think we have to be a sort of, I mean, I know I'm being sort of rather crude and, in a sense, cynical about it. But it seems to me from the structural papers that's the clear problem. Now, connecting that to Sudhir's very interesting discussion of the relationship between formality and informality in Indian legal system. Now, if you notice, I think even in Pratiksha's paper, I think most of us have a kind of schizophrenia about this formal-informal thing. in a first bet world, we would like everything to be formal. We would like everything to be formal for one particular reason, because in a sense, formality is associated with common citizenship, right? So the reason we don't let Sudhir sort of just voluntarily go out, set up court, is because, who's authorized him? No democratic government has authorized him. We won't collectively have say over what he can do, and we won't have, as collective citizens, ways of holding him accountable, right? So the idea of formal systems is in part very much tied to the notion of democratic legitimacy and democratic citizenship, right? That's why justice systems are not private markets, right? You don't go out and simply say, anybody's just allowed to set up shop. If people are coming willing to pay to come to you, so be it, right? Why don't we do that, right? We don't do that in part because, right, law has the imprimatur of collective legitimacy around it, right? So that's why we like formal systems. Problem with formal systems is formal systems are exclusive systems and they raise the cost of entry. Because what comes with formal systems is, in order to be a judge, you have to be so and so and so. In order to be a lawyer, you have to be so and so and so. In order to have those two things, right, the costs go up very dramatically, right? So the push to informality, in part, comes from the way to raise. So if you take the argument about paralegals, at one level, yes, we can sort of talk about, the paralegals as sort of, second best forms of justice. But I think the one kernel of truth it captures, right, is it tries to hold the system's feet to the fire and say, what's so special about giving lawyers exclusive privileges over certain matters, right? Why can't paralegals perform the same functions, right? By the way, in healthcare, we have similar problems in some senses, right? I mean, if you insist on only seeing doctors, you will actually raise the cost without necessarily getting better outcomes, right? Or you have the question of why only certain kinds of judges? Why do you have to have LLMs? Why do you have to be appointed by a very tightly controlled appoint system to have that authority, right? So in some senses, the push towards informality, right, is really an attack on a closed guild that extracts immense rents by using the power of democratic legitimacy for its own institutional power, right? And I think that's really, in a sense, the big contrast. And even if you see Pratiksha's paper, there's a kind of interesting tension on informality, because when it comes to the Lok Adalat, she says, how awful, right? But why how awful? It's confining citizens of a lower class to second-class rate forms of justice. Actually, not necessarily in terms of outcomes. It's not clear whether they're worse off or better off. In fact, we have absolutely no idea whether they're worse off or better off, right? But there's a perceived sense that somehow they're not accessing the rights of citizens, right? They're not accessing judges appointed through due process, imprimaturs of the, right? So at one level, if you think of judicial reform, fundamentally you have to think about this, why is it a closed, exclusive club? And to what are the mechanisms that it deploys to maintain its power as a closed, exclusive club? Right? I mean, to me, that's the core issue of access to justice at one level. I mean, it's very, 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 in a sense, oversimplifying. And what is lost if you actually opened up its very closed guild-like character by which it extracts rents? Right? In all kinds of ways, subtle ways. I mean, those are the biggest entry barriers to the justice system in some, in some ways. And I think in China there's actually, in a sense, a similar debate actually, which is, so mediation has this kind of interesting place in, as far as I understand, in Chinese legal discourse, but in our legal discourse, is the nice thing about mediation is that it doesn't challenge the structure of exclusive rights. Right? What it does is it provides a palliative whereby the pressure on that system doesn't build up enough that somebody gets up and really begins to challenge it. So the question I leave you for legal reform, and so maybe talk about it this evening a bit more, who really wants legal reform? Judges don't want it. Absolutely not. Right? For all the big, and one test of why they don't want it is simply look at the things that are under their control. that would actually reduce entry barriers, that would actually increase efficiencies, right? Power to grant adjournments, control over their own courtrooms, how those practices have actually evolved to actually raise costs rather than diminish them. Privileged lawyers don't want that because the entire system of, as it were, their system of rents depends upon that exclusivity and in turn the scarcity that's produced by it. Right? Lower court lawyers resist change and in a sense oppose legal reform. The biggest constituency for in a sense opposing legal reform because they feel squeezed between the hierarchies of their own judicial system or the prospect of all their stuff vanishing under this alternative mediation system. So unless we address that political economy, you're not going to get major legal reform, or rather you will get a lot of legal change in a formal sense, but it will reorient itself back to, as it were, that equilibrium. The last final point I made, which I think Sudhir raised a very important point, which is really about, and I actually agree with him. I mean, do even people want a better justice system? Certainly, if you're caught in the web of litigation, you do at that moment, right? But the fear that a better legal system might actually end up being more oppressive is a genuine one, right? I mean, right now you can bribe. I mean, the formal, informal ways of negotiating with this system. If it's efficient and it turns out to be wicked, what am I actually going to do, right? Now here's the, in a sense, the tricky question that then arises, which is, you can understand why there's a fascination with supply-side solutions. Partly because they're easy to fix, right? Increase the number of judges, computerized court systems. I mean, you can get a handle on that very easily. It really doesn't sort of upset anything else. I think partly it is also because, and this nobody really wants to talk about openly, our formal legal fiction is there is no tight relationship between process and outcome. That is what makes for a fair legal system, right? I mean, that's the mythology of the legal system. If you knew the outcomes in advance, then why would you actually need a legal system in the first place, right? And also because you don't want the process of legal reform to be tied to substantive views where there are actually genuine disagreements. You think it's a socially conservative judgment, Naveen Jindal doesn't think it's a socially conservative judgment, right? And frankly, that is the division in our society, right? So you're not going to, through processes, by definition, get guarantees that the outcomes will be progressive. For that, what you would need is a series of judges who have a certain conception of their own role in society. Right? The trouble is, it's very hard to justify constructing the role of judges in those substantive terms in a deeply politicized and divided society. It's also very hard to think of judges in those terms because then it undermines the founding myth of law, which is this is really about process and discovery. This is not about the judge's ideological predilections and their substantive aims. Right? But it does raise the interesting question, which is what is the self-perception of this exclusive guild, which having to manage to kind of create a system whereby they can extract rents, what do they want to do with their power? Right? And that requires, I think, much more complicated ethnographies and biographies, even, if you like, of the professional identity of that class, which we know very little about.
Thank you, Dr. Mehta, for that wonderful pulling together of the presentations and providing an insight on the forces that tend to resist the assumed reforms. you would agree that we have 4 very interesting and forceful presentations, and I do hope that you have some questions to them. I propose we have roughly about 20 minutes or so, and maybe therefore we should see with about 3 or 4 questions in round 1, and then there will be a set of responses, and if there is a little time left, we'll take a round 2. So may I therefore request you to identify if you have a question. 1, anyone else? 2? Okay, we'll begin. Oh, sorry, 3. Okay, so yes.
So actually, part question, part comment on Dr. Mehta's comments, actually, and partly for Sudhir also. I mean, obviously, for an argumentative purpose, you can question the foundations and say it's an inward-looking rent extracting system. Obviously, when you engage with policymakers, you can't use the same language. But my main concern is that when we are trying to assume that this is a rent extracting system, there are multiple tiers within the system which are constantly in conflict with each other. And there's a lot of writing already about it, like by writers like Robert Moon or Robert Peter, who've done local studies in India in the lower courts. And they've clearly established, and I think this is also, if you ask any practicing lawyer, that when you talk about repeat players within the system who might be opposing reform, there are multiple levels. And the primary function, or at least the person, if you look at it in a very narrow frame, is the trial judge. Now, there are many administrative practices which have been designed, such as the roster system, the promotion system, or even, let's say, the transfer of judges from one district to the other, which are meant to be safeguards against, let's say, a partial decision-making based on transfer kinship lines. And for the Indian setting, the argument was those measures were necessary. At the same time, they have a serious drag on efficiency. And it also means that more and more outsiders are confronting the local bar when it comes to, let's say, conflicts about specific local reforms within the trial court complex. It might be about scheduling or adjournments. So I think it's a little, I would be hesitant to paint the entire system in black. I mean, of course, I don't think that's what you intended to say. But there are multiple tiers and pressures within the system. And to assume that everybody is just thinking in the same frame is, I think, a simplistic assumption. Like, you have to make a good faith assumption that there are many people out there who do want efficient disposition, whether they're new practitioners or experienced practitioners, or people who have an intense set of clients or don't, or trial judges. I think we really can't aggregate them into one big mass. And there is work already out there which examines this. It's just that I think we haven't connected the threads of anthropology and what the law commission has been saying.
Thank you. I think that main point you wanted to score. Right. Jaina, you wanted to.
Yeah. This is just to respond to Dr. Mehta. You spoke about, why is it such an exclusivity of lawyers and judges? And there have been some changes that have happened, but they've not gone far enough. So, for example, in the family court and consumer courts, you have the base provision that people can come by themselves and they don't need lawyers. But you see that, for example, when they come by themselves, the system is so procedural that a client who comes on his or her own really cannot navigate through the procedure and handle the case. And so then it actually affects them worse off. I mean, it is advisable that they have lawyers. And so therefore, even the procedure has to change suitably if you're going to make it a system where you're not going to have lawyers. And in some cases where they tried to actually not have judges and to have other people sitting to adjudicate, like the KAT or the judicial, the JJ, the Juvenile Justice Board, it's actually not gone fully there because the presiding officer is a judge. So even if you have social workers in the Juvenile Justice Board, you have actually it's made up of social workers who are supposed to deal with cases. But the presiding officer is a judge. So everyone is kind of subservient to the judge taking the call. And so are we, if we have to remove the judges and kind of just make other experts sit on these bodies, then we have to make procedure that much simpler so that you don't, say that you need a legal expert or a lawyer to take you through those cases. So I think maybe it has to go hand in hand, like procedural reform and.
Thank you. Arun.
Again, just a response to this idea of judges being rent seekers. I suppose one of the interesting things is, why is it that in every issue of legal and judicial reform, the issue of judicial independence arises? And that may be somewhat unique to India. And I think it's got to do with our history. If you look at during the emergency, we have Articles 323A and B, which authorize the specialized courts and tribunal system. And if you just look at the Constitution, you think, well, that's interesting. There is a way of opting out of the formal system, and you recognize the formal system doesn't work. But if you look at the history of it, these were actually brought in by Indira Gandhi during the emergency, because she was completely frustrated by the regular court system, and she decided to bypass them. And if you look at the whole debate with the 44th Amendment, when they try and bring back some of those things, this I heard from Shanti Bhushan, who's partly going to be someone very supportive of the rent-seeking sort of court system. But when he was Law Minister and he moved the 44th Amendment, his whole point was there is a basis in, there is some value in having that court system, because otherwise in the name of efficiency and in the name of outcomes being certain, you can completely bypass the formal system. And if you look at 323A and B, we haven't implemented them very much, but you've had the administrative tribunal system. And there's debate about how that system works. Very often non-lawyers were taken, and people who were technocrats and did work. But they didn't, I think there's some evidence to suggest they didn't take basic principles of natural justice very seriously. And that did harm to litigants before them. So Shanti Bhushan's entire point in that, and if you look at any attempt, we recently had this company law board attempt as well. And again, it's lawyers perhaps being rent-seeking, but perhaps also being deluded by this idea that there is something about having legally trained people and judges in systems, which leads to some systemic values. And I think the whole point in those line of cases is judicial independence does matter. And the reason you insist on judicially trained people there is you don't have powerful executives sort of running through in the name of efficiency. And I'll give you an example. This is to do with Simon Chapman's presentation. And I'm in Singapore, and this is the Singapore Law Minister giving a public talk on what Singapore is doing to make itself a hub for arbitration. Right? And then he said 5 years ago Singapore was behind Hong Kong. Today it is probably abreast and if not going ahead. And the two factors that Simon mentioned, right? So you don't want courts intervening, and you want foreign arbitration awards to be implemented. The second part you can do through legislation. One of the things he said, which is interesting, is there were a few judgments that judges were giving, which were impeding Singapore's goal of becoming an arbitration center. So we just had a talk with the judges, and that's not going to happen anymore. Right? And that, maybe I'm trained in India and I have this background there, was to me very worrying and quite striking that a law minister can just say so. In India that will not happen. If a law minister were to say, I'm going to tell the judges what they should be doing, there will be repercussions, and no law minister or law officer would say it in that context. And I think that may be a good thing, because there are, and my paper tomorrow is going to be comparing judicial reform in Singapore and India. You could argue Singapore is an extremely efficient system. The World Bank praises it for being one of the most efficient legal systems in the world. There are still questions about access to justice in Singapore. So going back to the themes of the concept paper, how do we take access to justice and rule of law values, and things like independence of the judiciary. And I guess my point would be there might be some things there. You wouldn't want to dismiss all those as rent-seeking, though clearly there are those tendencies in a lot of the systemic reforms that we're going to discuss.
Thank you. Yeah, we'll take a few more, then we will have one final sort of response.
My question is about, if you look at the spectrum of forums, various forums available, you have a state-run system, then you have state-recognized forums, you have private associations, not necessarily recognized by the state, but yet provide dispute resolution. You could have a private system, a private association that may provide a non-violent way of adjudication, however, not necessarily legal. And then you have Maoist court. Here I would like to quote an example of contractual divorce. So, divorce through a deed. It is illegal, but yet it is non-violent. So what are your comments on such a system?
Yeah, I just wanted to make just a brief comment, kind of following up on Pratap on this rent-seeking point. And I didn't get the sense he got quite there, but maybe was pointing to it of whether exposing rent-seeking is a tactic for reform. And I'm just thinking through the implications of that on two fronts. One, actually, the practicality of it. So one thing I think that makes sense for us who work on these issues here is, I've noticed even with my limited interactions with the media, I see this self-censorship of the media. When I've tried to kind of put ideas out there on occasion about exposing, so the most famous one, the Chief Justice is, always is much more likely to be in majority decisions on 5-judge benches or larger. Why is this? He sets the benches. I don't even go and say that, but the implications there, no one really wants to talk about it in the media because they're so afraid of this contempt of court power. And what is the larger kind of chilling effect of that contempt of court power, and how much is that going to be a blockade to actual real public discussion if you're trying to find, the whole reason to bring out rent-seeking to a larger audience is to find allies. And everybody in India assumes parliament's rent-seeking, right? And members of parliament are rent-seeking. That's the whole, they probably over-analyzed, and just thinks every member of parliament's out there for themselves. And Pratap mentioned this point, and I know Brian Tamana has written about this a bit in the US, of this concern that the US Legal Academy has so dissected the rent-seeking and the ideologies of all the judges that it's taken away any of this sense of the mystique of the law, that the law is any kind of neutral arbitrator, and in that sense has really undercut the judiciary. And I do think, especially if you think the judiciary is one of the things that core institutions keeping the country together and unified, just us as scholars and us as a community, what is our responsibility towards that and towards that vision? Is it just a responsibility to, get out the truth at whatever cost, whatever happens, or do we want a broader strategy, or people who are thinking about this on how to go about this and what are the implications?
There's one final intervention. That would be final.
Yes, my question is to Dr. Mehta and Sudhir as well. I just wanted to put forth one point that Bakshi makes in her paper, that there is a tendency of systems like Lok Adalat and informal forums to kind of make a deep bifurcation between the rich and the poor and kind of take out the access of formal forums to the poor. But she draws this distinction, and she says that this argument against informalism is not against informalism per se, but against that kind of informalism that tends to move away from the formal setup, and that is set up to move away from the formal setup. So she makes that distinction. I just wanted your response on that point.
Okay, thank you for the very wonderful response. It is difficult to do justice, but in the given time, may I therefore request each of the panelists to be very, very brief in your responses to all the 5 or 6 questions that came. And I think we'll begin in the same order. Begin with Sudhir, then Simon, and then Pratap.
So I'm not going to try to respond to each of the comments, and I'll try to thread the response in a slightly different way. Pratap hinted that we need to have some understanding of the relationship between process and outcomes. And I had a section which I did not present, which was on why the value of process is in some ways underrated. And Pratap kind of suggested that in a society with deep disagreements of various sorts, you need to have some mediating formats for arriving at agreements even of the normative character. So I sense that we can't have an account of process that is too thin, which rests just on ideas of consent. That is, that if you put 2 people together in a room and they had disagreements, whatever they settle is fine. So we really don't need to, the process, the only process value that we recommend is settlement. That they somehow came around to agree. And I think that's too thin an account of the way we should think about legal systems. So I'm not, I wouldn't go down the line of saying that is enough. That is a baseline for thinking about legal reform. I think that the process values of arriving at settlement or at adjudication. The other presenter who set up the other questioner set up that you set up a spectrum of institutions. You called everything adjudication, and my sense there is that whether we're reading Sumner or Fuller, we must realize that adjudication means a certain form of dispute processing, and we cannot just elide those differences. So should we tier them and say that a certain subset of disputes are best processed through settlement, and another set of disputes are best processed through adjudication, or so on? Some sort of hierarchy of disputes, and I haven't I haven't parsed that whole universe of disputes to come up with a nice typology that this might fit with. It's a possibility, but what I wouldn't want to do is to through our process, because for me, and I'll just say two more points and conclude, the China presentation, and I've had the benefit of actually looking at Jiangyu's work before Mother, is that this instrumentalism to law seems to assume that we all know what the outcome should be. And in the Chinese experience, in Chinese political society, arriving at outcomes may be different. So it might just be a coordination problem. So again, Jiangyu hits at that. He says that the judicial court system is a coordination device. It simply aligns the interests of central and local party apparatuses. So it's a different device. I don't think that in India the judicial system plays that instrumental role, because there's deep disputes about outcomes, about the goods. And so my sense is that we have to then have a conception of process which is thicker than just any settlement. And that's how I would think about this problem. I think we need to do that carefully. So I agree with some of the comments that we can't take every insistence on process to be rent-seeking, but we have to recognize rent-seeking. So that's the sort of difficult terrain that we're on. I want to say two things though about the Simon's arbitration presentation, so I made my comment about Jiangyu's paper, but on Simon's arbitration presentation, what's interesting is that the significant disputes that are now arising on bilateral investment treaties, and what's being seen here, at least in the Indian domestic perception, is these are really sovereignty disputes. They're about what sovereign states can and cannot do. And once that nationalist frame gets cast, this is no longer about rule of law or process values. Did they actually adhere to public policy or not? And so that becomes a very serious issue when we think about arbitration in India. And my sense here is that while international arbitration is an important part of the story, we have a domestic arbitration scene which is also hampered in deep ways, and one of the areas that we want to work on, insofar as arbitration is a solution, even a partial one, to the wide array of disputes in India. Clearly what is going on now is not even measuring up on that scale. And so any thoughts on that would be interesting. Thank you.
Thank you. I'll speak very briefly, and I agree absolutely. I think that it's very important, even though I've focused very much on international arbitration, which is my area of practice. Domestic arbitration is equally important, and I think one of the difficulties with domestic arbitration in India, at least the perception from outside of the jurisdiction, is that it's dominated very much by senior judges or retired judges being appointed as arbitrators, and so query whether actually it is a form of alternative dispute resolution, or whether in fact it's just another forum in which judges are still very dominant. I just wanted to pick up very briefly on the point about judges being resistant to change, and that being one of the big obstacles. The first point that I would make is that's certainly not something which is unique to India. It happens all over the world, and I think England and Wales in particular, and London, has only really in the last decade or so emerged as being a leading arbitral centre, because I think for a long time there was a perception that the English judiciary were far too interventionist, and certainly the historical legislation in London was quite restrictive and didn't give arbitrators the freedom that they have nowadays. I was also at a conference a couple of weeks ago about the new ICC rules. The ICC obviously is one of the major international arbitration institutions based in Paris. And the new ICC rules introduced this provision for arbitrators to grant interim measures in emergency situations, you can go and appoint an emergency arbitrator who will be appointed within 24 hours by the ICC. And that emergency arbitrator then has the power to grant freezing injunctions, for example, over a party's assets, which you can then go and enforce. And there was a very senior judge from the Hong Kong courts at this conference who was outraged at this notion of arbitrators usurping judicial authority in this particular area, and questioning why an arbitrator would be competent necessarily to handle something as complex and as difficult as a freezing injunction. So it's certainly something which is not unique to India. I think actually in the Indian context, one of the things that's very interesting is that although a lot of the issues that I discussed in the context of international arbitration are judge-made problems, what we're looking at now is judge-driven solutions to those problems. So the Bharat aluminium case, for example, is the Indian judiciary looking back at a previous line of cases, recognizing that there is a problem and then trying to do something about it. There is also an issue that's ongoing at the moment about the ability of foreign lawyers like myself to fly in and out of India to represent clients in international arbitrations which are seated in India. As most of you I'm sure will know, international law firms like Herbert Smith cannot open in India. But there's a question mark about whether we're entitled to fly in to do the advocacy, for example, at a hearing that's in Bangalore or anywhere else in India. The case in which Herbert Smith was actually one of the international law firms that was sued as a result of this, the first instance judgment came out recently, and it's quite interesting to look at the comments of the judge dismissing the case and finding that international lawyers should be able to fly in and out. Was that he said, if we do this, it will significantly impair India's standing as a hub for international arbitration. And that really leads on to the point about Singapore as well, which is one of those jurisdictions which, and it's an amazing transformation in the space of not very much time at all, which now is one of the leading arbitration venues. And really that significant will of finding that international arbitration in itself is big business. So it's not necessarily just foreign investors who are driving this, but it's the countries themselves recognising that it's actually a good thing to be recognised as being an arbitration-friendly jurisdiction and to be a hub for arbitration. And so trying to encourage and to foster some of these developments to make sure that some of the problems that I've identified with regard to judicial intervention and enforcement of awards are not seen as difficulties to outside investors. Thank you.
Very smart lawyers upset, so I better say sorry. 2 or 3 quick points. One, I'll begin with Arun's and then sort of move out. Absolutely. I mean, I began with this point. There's a reason why formal systems are important, and that has to do with democratic legitimacy. I mean, that was a shorthand for all kinds of things, right? And I sort of revere all of that. I think, nevertheless, I think there are 2 different issues. One, and this, going back to Sudhir's point about what kind of empirical research we want, I think is a genuinely tricky issue. Most of our accounts of which institutions represent these values, right? So why do we trust the judiciary more to represent, to respect constitutional values than Parliament, for example, at a very macro level? Or why do we assume that high courts will respect these processes' values more than alternative fora? At one level, we have to honestly admit we have absolutely no empirical basis for making any of these claims. Okay? I'm one of those who actually does genuinely believe, is still willing to put the fate of Indian democracy in the hands of politicians more than judges or bureaucrats. We can have an argument about it, but I think the point is that at one level, I think these arguments have become part of a kind of self-mythology of those institutions, right? Which then allows them to shield off certain kinds of scrutiny, and looking at actual practices of what actually happens. When I see a lot of what happens in high courts, I don't see a lot of that process value that you're talking about. Now that doesn't mean that all courts are bad, all judges are bad, but I just don't, you know, if you're taking the body of Indian citizenry and saying different guilds, as it were, that contribute to the maintenance of these democratic processes, I think the claim by the judiciary that it's paramount, better, exclusive, frankly, I'm a little bit skeptical of that. So in that sense, it's a, you know, but it's from a research point of view, it's a very tricky question of how would you settle this argument. You know, Neil Commissar once made this argument about pragmatism of institutions, that the issue is not what the form is, the issue is, in a sense, try and create it and perpetuate it, or perhaps even extend its power to the maximum extent possible. I mean, let's kind of just begin with that. And in some ways, right, if you look at the history of courts, the expansion of their powers, all of that, there's certainly a context that enables it. Right? But they are situated in a field of forces, in a field of other institutions. And rents really is really about that structural power. It is not about the actions of individual judges or whether individual judges and so forth are. So within that overall structure, of course there is a lot of innovation and emphasis on trying to deliver justice better, right? But the interesting thing is most of it is focused entirely on the question of internal efficiency of hierarchy in some respects. Let's get more judges, let's get more process from it. Now, the one interesting point you made, which was that I think part of the challenge in the Indian debate, and I'll sort of end with this, is we find a particular problem in the system, right? Let us say too many judges having too many local roots, and therefore likely to be surrounded in a web of complicities. We then come up with an institutional solution. Let's transfer them, right? I think the difficulty we have is that the externalities generated by any of these procedures, we don't have any ex-ante account of how they will actually work out, right? So a lot of those interventions are in a sense negative. Because we've been doing X, let's do Y as the opposite, right? I think in the selection of judges, that's a very good example. So for example, because we are afraid of discretionary power, because we think it can be abused, we try and say, let's have rules of thumb like seniority, right? Cumulatively, does 10 years down the line that produce a better judicial system? I don't know, right? But I think it is important not to, I mean, in a sense, or at least critically discuss whether there is actually a rational basis for these interventions, or are they in a sense negative, will we be always in judicial reform hostage to those 2 years in the history of government, government of India, right? I mean, in some senses, that's actually now hampering us in some ways. But I agree. I mean, and in any system, complex as the judiciaries, there will be different forms within the judiciary of this kind of, in a sense, authority. And it's precisely in those cracks that some light can shine. So I'll end with that. I'm sorry I haven't answered all the questions, but maybe